procedure relating to criminal trials, whether summary trials, trial on indictment, and so on and so forth, and then relating to how you treat evidence in criminal matters. So it does not create bodies. So I would not, to your answer, there is nothing about oral in in Act 30. Now, the question whether oral is legal has been raised, by various people within the media, all right? Oral is the Operation Recover All Loot. If you look at the preamble to the Constitution, it is very, very clear about what are the fundamental values underpinning the Constitution. The value of accountability is one of the preambular commitments in our Constitution. It's a primary value. Oral is supposed to exact accountability from persons either politically exposed or persons holding public office who used or misused their office to loot public resources by way of property, money, and other intangible resources. So oral is constitutional. Oral is legal. In fact, the fact that it is a non-legal body doesn't mean that it is illegal. There's a distinction between non-legality and illegality.
Mr. Chair, please, if I may be allowed a follow-up.
Yes, you have my discretion. Before then, let me hear from Honorable Ayerga.
Mr. Chair.
He's coming in on a point of information.
Mr. Chairman, if you open the Constitution to Article 41, Article 41 deals with duties of a citizen. Please, everybody, listen to this. Article 41 deals with duties of a citizen. 41F says one of the duties of every citizen of this country is to protect and preserve public property and expose and combat misuse and waste of public funds and property. So if somebody forms a committee to elicit information about instances of looting of public property and waste and resources, is it not to provide an avenue for compliance with this constitutional provision? Is that not what it is?
No, we are.
And how different is this campaign from the campaign that took place recently? See something, say something. If you see looting, say it. If you see stealing, say it.
Mr. Chair, my follow-up.
Honourable members, reiterate the fact that Honorable Ayerga, you are even not supposed to react. So observe the proceedings in silence. Honorable Ayerga, we are grateful for the point of information.
Okay,
you want to ask a follow-up question?
Before my last main question.
You are permitted to ask the follow-up question.
Mr. Chair, it is very interesting to note that notwithstanding Article 41F, the Criminal Offences and Procedure Act, Act 30, provided or has made provision for investigations, arrest, and prosecution of criminal offenses. And it still doesn't include oral or private individuals acting. But my follow-up is this. My follow-up is this. My follow-up is this.
What you've just said was a preliminary comment, but not a follow-up question.
Mr. Chair, teacher, I plead with you to indulge me in the interest of Ghana. Roxanne, you promised to protect.
Please go ahead with your last question.
Okay. So, in the year 2010, the NDC administration under Professor Mills commissioned the Constitution Review Commission that presented its report in the year 2012, for which a white paper was issued in June 2012. Hope you remember. Good. Now, you spoke extensively seeking to justify tribunals, the establishment of tribunals. At page 21 of the report of the Commission of Inquiry, of the white paper, on the report of the Constitution Review Commission, at page 21, the white paper stated as follows: maintenance of regional tribunal in court structure. Government accepts the recommendation that regional tribunal be abolished and matters handled by them incorporated into the regular court schedule. Government, however, holds the view that the chairman of the regional tribunal, if any, should be absorbed into the judiciary as high court judges. This is by an NDC government. The question is that when you had previously accepted the commission's report to abolish the Commission of Inquiry, to abolish tribunals, and now you say you are bringing it back, is it not double speaking? Especially when you have also failed to provide before us what the High Court is not doing that you want to correct with the tribunal. Is it not double speaking without any justification? Dated 2012, yes.
So what is the exact date on the report?
The report...
You are referring to the white paper
I'm referring to the white paper.
The report of the Constitutional Review Commission?
I'm referring to the government white paper stating its position
Very well.
on the report.
Very well. Honorable nominee, your response.
Yeah, thank you, Mr. Chairman. I'm very much aware of the position stated by the honorable member. I was very intimately involved in the work of the Fiajo Constitutional Review Commission, which was headed by my own good friend and former colleague, whose secretary was my own good friend and former colleague, the current dean of the University of Ghana Law School, Professor Raymond Atuguba. I am also keenly aware of the fact that the government white paper accepted to abolish the recommendation of the commission to abolish the regional tribunals. However, an American justice of the Supreme Court, a justice of the Supreme Court of the US, very famous, Oliver Wendell Holmes, he once said that the life of the law has not been logic, but experience. When experience has taught us that there are deficiencies in our justice system. In fact, when the honorable nominee was talking about the honorable member, I'm sorry, I have been here since 9:30, you have to forgive me. When the honorable member was talking about delays, he's a legal practitioner and he knows that the traditional court system is also plagued with a lot of delays. You also know that sometimes they disregard the fundamental human rights of citizens. during the tenure of your own government, Afoko Gregory, when a court of law ordered that he should be granted bail, you still callously detained him, and he's in detention now. That's a violation of the right of Gregory Afoko to liberty. So these things occur whether you are dealing with the traditional court system or a tribunal system. Okay? The good thing is to have men and women of integrity who will administer the law or administer justice in accordance with law. And that is what we are seeking to do with the re-establishment of the public tribunals. I think that our experience has taught us that the participation of ordinary citizens in the justice system is a good thing. And that is why, having thought about it, we are re-establishing it. But of course, we are governed, as I said, by a constitution, and I believe that there will be limitations to the powers of the tribunal as far as respect for the rights of persons appearing before them is concerned.
Thank you very much. I recognize Honorable Roxanne Nelson Kwame Eche Dafamapo for a supplementary question.
Chairman, thank you very much. Professor Ayine, you are welcome.
Thank you, Mr. Chair.
You taught me, and you taught me well, and I'm very happy that you got this nomination. Now, you're also my chairman of the Subsidiary Legislation Committee, and I second chair you, and I know the quality that you put into your work. So you also taught me legal system. So let me clarify this. Are you actually saying that you are going to establish or create these tribunal courts, or you are going to implement the law? Because Article 142, Prof, is very clear in the establishment of tribunals. And it says, Chairman, with your leave, Article 142.1 says, there shall be established in each region of Ghana such regional tribunals as the Chief Justice may determine. Now, the Courts Act, 1993, variously amended in 202 and 203, actually imported Article 142 into the Courts Act and actually added more in terms of the creation of the regional tribunals. So when the impression is created that you are going to create these court systems, I got confused. So I want to find out from you, are you going to rather implement the law, asking that regional tribunals be established, shall be established, or is going to be your creature by policy? Chairman, thank you.
Mr. Chair, on a point of order, he said that the Courts Act.
You don't have the floor.
He says.
You do not have the floor. Even at point of order, I need to give you the floor. Honorable nominee, may you proceed to answer the question?
Well, I agree with my former student that I taught him well. He's drawn a distinction that I glossed over. The tribunals are actually established by the Constitution under Article 142. Now, the Courts Act was variously amended, and sorry, Mr. Chairman, but I don't have the amendments here, but I do remember vaguely there was an attempt to delete provisions relating to the tribunals by the VCRAC committee. So if you take the compendium, the green compendium, I think that was where it was done. And the idea was to take them out, in terms of the statutory implementation. So what I would do, if Parliament gives me the nod, is to overhaul the law relating to the public tribunals by bringing a new bill that I will introduce rapidly because the president has hit the road running, and we, his nominees and his appointees, are his, supplementary wheels. We have to help him, to run as fast as possible. So I will bring a bill that will comprehensively deal with the implementation of the letter and spirit of Article 142 of the Constitution. Thank you very much, Mr. Chairman.
Thank you very much. Yes, you want a point of order. Is the point of order relating to the answer or the question being asked?
Mr. Chair, both. It made reference
But
to an
you know, under the rules, you cannot take a point of order on a question being asked.
Mr. Chair, on the answer. On the answer.
Now, tell me what exactly is the answer that you are taking the point of order on?
Mr.
And
Chair,
what is your point of order?
Very respectfully. The Courts Amendment Act of 2002 amended the Courts Act of 1993 to abolish the district and community tribunals. So the only tribunal which remains on our statute book is the regional tribunal, which the Constitutional Review, government has accepted the Constitutional Review Committee's report to abolish. So that is the only tribunal which is on our statute book.
So how different is that from the answer provided by the nominee, that he doesn't have the Court Act here, but he believes of an attempt to take it off from the Court Act? So it's not different.
Mr. Chair, very respectfully, this is a committee of record, so it is important that records are set so that listeners will know that it doesn't exist anymore.
Then pose a question is John Dako.
Thank you, Mr. Chairman. Honorable nominee, I'm sure you are aware of a company called Cassius Mining. That company obtained a grant of prospecting license from the Minister for Lands and Natural Resources sometime in 2016. Actually, 14 days after the Mahama administration had lost power. The company at the time did not comply with the prospecting license. And they had made an application for renewal of the prospecting license. Following that, Honorable nominee, you became the counsel for
Honorable Member,
Cassius Mining.
do you have the evidence that the company did not comply? And in any case, that particular company is not before us. So you know the rules relating to speaking about persons who are not before us and will not have the opportunity to defend themselves. So be guided.
Thank you, Mr. Chairman. So following that, Mr. Nominee, you became the counsel for Cassius Mining and made demands on the government for renewal of the company's prospecting license. In fact, Mr. Nominee, you, as a lawyer for the company, you wrote a letter dated 21st February 2020, attention the Chief Executive Officer of Minerals Commission. You stated variously, but in particular, clause 4 of your letter to the Chief Executive of Minerals Commission, you stated that the fact that the two shareholders of the company prior convictions cannot vitiate the license, it is not a relevant consideration. You stated, Mr. Nominee, that it is spurious and disingenuous for you to suggest that the minister can, on this basis, refuse to grant the license renewal. But even if it were so, damages will still flow and the government of Ghana will remain liable. Mr. Nominee, it will interest you to know that about 2 weeks ago, this company, Cassius Mining, for which you were once their legal counsel, has filed an arbitration against the government of Ghana, claiming in excess of 440 million United States dollars at the London Center of International Arbitration. The Attorney General of the Republic of Ghana is supposed to defend the Republic against all claims, including one such as this. Now, you were once the lawyer of this company. You believed in their claim against the government of Ghana. Mr. Nominee, are you going to ensure that when the Republic goes to defend this claim, the Republic of Ghana will not be burdened with this $441 million? And I'm saying this because of the appearance of conflict of interest.
I recognize Honorable Kwame Agboja.
Leader, the procedures here will all encourage our first-timers to participate fully in this. Indeed, that is why our side and the side of the minority brought in first-time MPs. But in this committee, you can lay preamble to ask your question, but not to make, endless statements. And I sit here and ask myself, when is the question going to come? So, Chairman, can you direct that it is not against the procedures here to lay a preamble, but that must be brief, then you go to your question. Because I get lost as to whether somebody is making a statement or asking a question.
You see, Chairman, people, Honorable Whip, people sit outside and sometimes they bash the members of the committee. Being outside and having the opportunity to ask the question are two different things. We now have the opportunity, pose the question, but I will allow the nominee to provide an answer.
Thank you, Mr. Chairman. Mr. Chairman, the honorable member is right. I have been instructed previously by Cassius Mining. I filed pleadings in the High Court in Bolgatanga together with my junior partner, Mr. Gorin Tamaklo. We litigated, various applications before the courts. I want to put it on record that I'm no longer Cassius Mining's lawyer. However, I'm keenly aware of the fact that the Constitution prohibits a situation where a public officer puts himself in a position where his private interest conflicts with the performance of his public duties. As Attorney General of the Republic, I will be the Republic's lawyer. As the Republic's lawyer, I am supposed to act in the best interest of the Republic, in accordance with the best traditions and ethics of the legal profession. I will not, in any manner whatsoever, compromise the interests of the Republic of Ghana. Honorable Member, if you care to know, and I'm sure you are very well aware, that I was Deputy Attorney General under the former Attorney General, Honorable Marietta Brew. And for 4 years, we handled that ministry in such a way that the US government described the Attorney General's office as a corruption-free zone. We handled the ministry in such a way.
You are not supposed to take part in the proceedings. So remain silent and observe the proceedings. You are only here to observe.
So, Mr. Chairman, when we were in office, you can go back and check the records. There was no single incident, except the Wyoming matter that came before we assumed office. There was no single incident of questionable judgment that's arising out of or in connection with the performance of the obligations of the Republic in any contract or legal transaction. So I can assure the House that I will take measures if they are before the London Court of International Arbitration. I'm quite familiar with that tribunal. I've appeared before that tribunal several times, and I can assure you that I will put in the measures that will ensure that the interest of the Republic is not compromised.
Thank you very much.
To follow up, Mr. Chairman, with respect.
Yes, go ahead.
Mr. Nominee, do you believe in the propriety of their case against the Republic?
With all due respect, I believe you have indicated the matter is before the court. Is that not so?
Mr. Chair, I think
And
it's a fair
he
question.
is no longer the lawyer for the company. So in vetting the nominee, you cannot be soliciting for his opinion on that particular matter. So ask another question.
Okay, no. I never said I don't have any.
Please, have you finished asking the question?
No, since you didn't allow him to answer that question, I'll move on to another one.
Well, I have the right, if I feel the question is soliciting the opinion of the nominee, I can overrule you.
Even if he can answer, Mr. Chairman, I understand.
The question is overruled. If you are done, let me give the opportunity to another person.
Mr. Chairman,
I believe you are done.
Mr.
I will
Chairman,
then give the opportunity to Honorable Shaibu.
Mr. Chairman, with respect, I am not done.
Honorable Shaibu, you have the floor.
Mr. Chairman, with respect, I am not done.
Chairman, with all due respect, please allow him to conclude. Please.
Mr. Chairman, thank you very much for your understanding. Mr. Nominee, your firm is on record as having acted for a number of companies which have gone on to make huge claims against the government. In some of these cases, the companies were formed between the year 2013 to 2017. Your firm was the law firm which acted as lawyers for the firm, for the firm. At the same time, you were the Deputy Attorney General. After you left office, the companies proceeded to go on international arbitration against the Republic, claiming millions of dollars. We have an example in GPGC, which was the claimant in the Trafigura arbitration case. Mr. Nominee, your law firm's address, Ayine, Feli & Co., is on
Honorable John Dako, the nominee told the whole world that he is mindful of the conflict of interest situation. When he was a Deputy Attorney General, nothing of that nature happened. He's now before us to be vetted for the position of the substantive Attorney General. Why do you keep on asking questions relating to his law firm?
Mr. Chairman, I think it's very important. The honorable nominee, which I know very well, is going to be the chief enforcer of our laws. And so, Mr. Chairman, and he's capable, I know him very capable of answering any question posed to him.
It is
So
not
if
the
he is going to-
capability.
Mr. Chairman,
It's not the capability of answering the question, but we need to be guided by the rules. You know, the law firm Ayine and Associates is different from Honorable Dr. Akuditinga Ayine.
yes. Yes.
So-
But it doesn't mean that he cannot answer. When there is a semblance of conflict of interest, I think that it will be in his own interest to answer that question, to clear the minds of all of us.
Honorable members, do you have any further question?
Mr. Chairman,
I ask the nominee not to answer such a question. I will now give the floor.
Mr. Chairman, I think you are being unfair to me. Yes, Mr. Chairman, if you believe that, for instance, this question
Did you say I'm being unfair to you?
Yes, Mr. Chairman, with respect.
Why do you say so?
Because, Mr. Chairman, you are not allowing me to ask the questions I'm supposed to ask.
But I have the right to overrule you.
We represent
We are
the
guided
people,
by rules.
and the people need
But
to
we are
know.
guided by rules.
The people must hear
Are
the
you aware
question
we are
and they
guided
must
by
answer.
rules?
Yes, Mr. Chairman, but I don't
You
think,
cannot even ask incriminating questions.
I don't think at this point I have violated any rules of this House. Mr. Chairman, I haven't...
Where lies the question of conflict of interest? When the nominee has already provided the answer.
Mr. Chairman,
Honorable John Dako, you are out of order. I give the floor to Ahmed Shaibu.
Order, Chairman.
I give the floor to Honorable Ahmed Shaibu.
Chairman, order. Chairman, I want to intervene.
We have Ahmed Shaibu and Mahama Shaibu.
Chairman, colleagues.
So, Honorable Minority Leader, you have the floor.
Chairman, before I go into colleagues, please, let's resolve matter. Chairman, I am making this point. If you check our rules book, you have the chairman of the committee, and you have the vice chair, and you have the ranking, and you have deputy ranking. In principle, what our standing orders is trying to say is that there is a presumption of a co-chairing of this exercise. Otherwise, if you will never, you would always want to have your say, but you don't want others to speak. That is your problem, NDC. That is your problem. Yes, we don't. Okay, if that is what you want to do, you're right, no problem. You will listen to me, Chairman. You can't say out of. You can say you've said that to my members. If you now want to extend it to mean that I'm out of order and order, let's have it. Can the vice chair leave?
If the standing orders has
Can I finish? Can I finish, my respected vice chair? Can I finish? Chairman, we are here. We are here to work as a team. The rule talks about the chair and vice chair. If this committee is to deal with a sole chair without anybody to work to express a view, it would have limited it to chairman and vice chair and nothing else. In Parliament, whenever there is a chair, there is a ranking. It is not to checkmate, but to work together and to express views of the House. When we try to put issues across, we have some of your senior colleagues who reach out quietly to say, please, you are going too much. We listen to them. We want to work together. But Chairman, with the greatest respect, I have observed consistently the way you go at my members, especially the young ones, the new ones. It's not the right way. I've been quiet watching, and I will just be pinching you, the chairman. Please, you take it easy. Take it easy. But the way it is going, I think it is not too right. To the extent that, as your co-chair, and I want to state this on record, well, the standing, don't worry. If you give it a purposive interpretation, it will lead you to that conclusion. Please, let's understand each other. This vetting should have taken place tomorrow, all three of them. We mean well, and I want to state that on record. We mean well as a minority. We cooperated to have days, 21 days or 15 days notice to be waived so that you can form your government as quickly as possible. I am pleading with you, Chairman. Chairman, I am pleading with you. I am pleading with you. I do not. Can I finish? No, I'm not done. I want to be Honorable Mahama Yerga. I need to be done. I would have to be done. I do not like this situation whereby your side is still behaving as though you are in the minority. You are not in the minority. You are now in government. You are now in government. Please, we mean well. It is the reason why we are here. Stop the approach you are adopting. I am pleading with you. I am humbly pleading with you, Chairman. We plead with you. The approach will not help all of us. The approach will not help all of us.
You see, honorable members, I will give the floor to...
Chairman, he did not finish. Please. No. Chairman. Chairman. No, he didn't finish. No. He had called somebody. Chairman, all my plea is... Chairman, I beg you, allow him. Chairman, please. Chairman, please.
You see, honorable members, we don't sit here to gag any member, but we rather give you directions. The fact that we are guiding and giving you directions as an honorable member of parliament, you should take a cue and proceed. If I want to apply the rules strictly, as the former First Deputy Speaker have been doing, what happened today, we may not be experiencing some of those things. According to him, you are asked to ask a question, you ask the question, but we have allowed you to run commentaries, sometimes to read write-ups before asking the question. So I would urge all of you, particularly the new members, to take guidance from the chair. We are here to guide you. We are to guide you. So if you still have one more question, you may proceed to ask the question. I'll give you the floor after that. Hold on with your question. Let me give the floor to Honorable Kwame Agboja.
Chairman, you see, nothing happening today.
Please, let's have order. Order.
Chairman, what the minority leader said about NDC being intolerant or they have been more cooperative is totally untrue. Mr. Speaker, Mr. Chairman, we've had situations when the president nominated people on Friday and we came here on Saturday to fetch the people. No advertisement or anything. So what is the minority leader talking about? That they have been more cooperative than us? That is not true. What we are saying is that, yes, indeed, we've had first-timers in the House, indeed, in the chamber. We've seen first-timers from both sides walking across the maze because they were not yet gone through orientation. So when, unfortunately, they haven't gone through full orientation, they come to committee, and instead of asking questions, coming to read statement, it is appropriate we put them right. That should not be a situation anybody could interpret to mean that somebody is being gagged. And let it be known, as a matter of fact, at the appointment committee, we never allow friends or non-members to ask questions. It's because we wanted to carry everybody along that we give them the opportunity. So, Chairman, I would encourage you once again, stick to the rules. When you give an opportunity to somebody to ask question, let that person ask the question, and let's move on. This endless rhetoric of trying to quote things and never relate it will not help anybody. Mr. Speaker, Mr. Chairman, let's make progress, but let everybody who gets opportunity ask the question and let answer the question. Chairman, I also noticed, anyway, you go on.
Thank you very much, Honorable Naomomo Latte.
Thank you, Mr. Speaker, Mr. Chairman, for indulging me. I am very much concerned about what is happening here. And in as much as we don't want it to look like newcomers are being gagged, I think that parliamentary practice and procedures transcends the presence of this parliament. If we want to do it, we have to do it right, because you'll be going out there meeting other parliaments. So in the name of supporting first-timers or newcomers, all of us are still learning. But if we refuse to learn the right way, we will go out there and embarrass not just ourselves, but the Parliament of Ghana. So I'll plead with us, in as much as we want everybody to have the freedom to express himself or herself, let us do it within the laws, so that when we go out there, we'll have the confidence to operate. Leadership will not be there all the time to protect us. Even leader might not be on the floor of parliament every time we have to rise and talk. So if we don't learn it the right way, we are the ones who are going to suffer. So I'll plead with you, let's do it the right way. Thank you.
Thank you very much. We've been patient the whole day. Sometimes you get up and put on the microphone without being given the floor. We've been tolerant. It doesn't happen anywhere that you get up and then you put on the microphone. Somebody is asking a question. Then you said you are on a point of order. How do you take point of order on a question being asked? Well, we said we have one question more. May you proceed to ask the question.
Mr. Chairman, thank you very much. I want to believe that everything is being done from a good place.
Can you proceed with your question? Can you proceed with your question?
Yes, leader, thank you. So, Honorable Nominee, my question is, have you filed your asset declaration?
He's asking whether you have filed for asset declaration.
Yes, I have. I'm always complying with asset declaration. The filing of asset declaration. I've done that. Not for 2025, but for the last parliament, I filed my asset declaration.
Which is 2020, ending 2024?
Yes.
Okay. But I don't think the committee has a copy. Or evidence of filing.
Has just gone through election and was elected the 4th time as a member of parliament and sworn in as a member of parliament. So let us be guided by the constitutional imperative in Article 78 and 94.
Thank you, Mr. Chairman. So, Mr. Nominee, your law firm, that is Ayine, Feli & Co., is on record to have been used as a registered address for a company called GPGC. Now, my question is, did you advise on the agreement between GPGC and the government of Ghana, of which you were the Deputy Attorney General then, and which led to a judgment debt of $134 million against the state?
Okay. So, Mr. Chairman, it is important to set the record straight because this is a House of Record. This is a Committee of Record. I became Deputy Attorney General, I think, in April 2018. When I was nominated, because I did not have the right to practice, my firm, or the firm of lawyers to which I belonged, was being run by Dr. Abdul Basit Bamba. And when GPGC came into Ghana, he was a lawyer who was approached to help them navigate the process of company registration. And he was the one who registered to me because I came from academia. And one of the things that the subjects that I taught, and I'm sure you took my natural resources law course, I was the head of the natural resources law department that included, petroleum. So she subject to reporting to her, I was in charge of the petroleum and energy aspects, of any transaction that came to the department. Yes, so I issued a legal opinion on GPGC, all right, which was, because the PPAs are standard, the provisions are standard. You can take any normal PPA, the variations are not many. So I issued a legal opinion for them. I mean, I signed it for and on behalf of the Attorney General. So technically speaking, it was Honorable Marete Bruce's opinion, not mine. But whatever the case, when the dispute started because of the actions and omissions of your government, I was no longer in office, and I never acted as a private legal practitioner in any of the disputes. Mr. Chairman, that's all I can say for now.
I believe you have exhausted your questions. It is now the turn of
thank you.
Jerry Ahmed Shaibu.
Mr. Chair, thank you very much. The name is Shaib, S-H-A-I-B, with all due deference. Dr. Ayine, congratulations.
Thank you.
Doc, in 2021, during the hearing of the election petition, you were cited by the Supreme Court of Ghana for scandalizing the court. The matter was referred to the General Legal Counsel. The matter is still pending. My view and my question is that, are you, with all due deference, not in the position to have the matter resolved before you take up this high office of Attorney General and Minister of Justice? Thank you.
Yeah, thank you, Mr. Chairman. Thank you, Mr. Chairman.
Honourable member, before you come in, the matter is pending quasi-judicial decision. I believe we have a lot of members of parliament who have been sworn in with the matter pending judicial decision. To what extent does a member's involvement in a pending lawsuit disqualify him from being a member of parliament, let alone a disciplinary proceedings against a member? So, with all due respect, we need to be fair to all manner of people, and we ask very fair questions to the nominees. So, ask another question with all due respect.
Mr. Chair, thank you very much. I'm not too sure if I can respond to your question before going to the other question.
See, that is why I've indicated that the practice in the House is that you are guided by the chair. You are guided by the speaker. So you take the guidance and proceed accordingly to ask another question.
Very well, Mr. Chair. I take a cue. Dr. Ayine, during the Mills Mahama government, in which you served as the Deputy Attorney General, the state lost a number of international arbitration cases and local ones as well. And to a larger extent, some amounts of monies involved were quite humongous. My question is that how do we prevent the recurrence of such situations? And the case that comes to mind is the Balkan case. Thank you.
Thank you very much for your question. Nominee, your answer, please.
Yeah, Mr. Chairman, there is never a perfect government. And so sometimes public officers act in a manner that incurs liability for the Republic. But as I said, when we were in office, we did very well in trying to prevent such situations. The Balkan situation arose before I took office as Deputy Attorney General. And in fact, by the time I was Deputy Attorney General, the arbitration was at an advanced stage. In fact, I think they were awaiting the award. And the award came down in favor of Balkan. I think it was about $12.5 million or something to that effect. $13 million in favor of Balkan. For us to be able to prevent such situations, state actors, I mean the ministries, departments, and agencies, and the public officers must make sure that they do the right thing. So, for instance, one of the things that I want to emphasize, which we started briefly before we left office, was for us to conduct legal due diligence, of all companies that are seeking to do business with the government, especially where the stakes financially are very high. And so we will attach the legal due diligence report, even if we ourselves cannot do it. We'll get private law firms to conduct the legal due diligence so that we do the right thing by the law. Mr. Chairman, I think we're all in this country when a certain huge transaction came before Parliament, and then when the company was being traced to London, we realized it was a hairdressing salon, CNTC, and it was not President Mills who was in power. It was not His Excellency John Dramani Mahama who was in power. It was His Excellency John Agyekum Kufuor, a man that I respect very much, whose government was in power. It was a hairdressing salon, Mr. Chairman.
Thank you very much. Any follow-up question?
Last one. Thank you, Mr. Chair. Dr. Ayine, so my last question is, what are the kinds of agreements that ought to receive parliamentary approval under Article 1815 of the 1992 Constitution?
I'm surprised my former student is asking me this fundamental question. Were there loans loans and, international economic or business transactions in which the government of Ghana is party, or to which the government of Ghana is party. Thank you, Mr. Chairman.
Thank you very much. We now take a question from Honorable Samia Uku.
Mr. Chairman, thank you for emphasizing that a question. Congratulations, nominee. Doc, I want to refer you to an interesting case, a case of a company called Eland International. And I want to believe that you are familiar with the company Eland International. And in laying the foundation, just for a minute before my question, Eland International, sometime in our history, had a case and made a claim subsequently to the international arbitration, where, as we speak, since 2005, they only waited to file these arbitration claims of $320 million against the government and the state of Ghana. I'm also reliably informed, and I stand to be corrected, that sometime 2014, 2015, when you happen to be the Deputy Attorney General, you tried to settle this matter somewhere in India and Dubai. So I stand to be corrected on that. But there was somewhere in 2014, 2015, in your capacity as a Deputy Attorney General. Now that they have filed these claims of $320 million, and being a company that you are familiar with in terms of the history of this case, what assurances can you give the people of Ghana, and for me, my constituents in Akuapem North, that our incoming principal legal advisor to government will be fair in handling this matter so we do not lose revenue? And I'm asking this because, respectfully, if you will just observe, many of the questions hovers around judgment debt. And I'm not taking a partisan position on this matter. And it's because the state, over several decades, we have lost significant revenue through some of these claims, whether under government A or government B. So it's become an industry for some people, an element that some operate across these political parties. And also, lastly, for the record, it's not just Woyome case that preceded you, but also under the same Mills Mahama government, you had Isofoton and the rest as well, just as a matter of record. Thank you.
Thank you very much. May you proceed to answer.
Thank you, Mr. Chairman. I want to put it on record that I have never served as counsel for Eland. Yes, I was involved in two aspects. One was the case, the famous promissory note case that was brought by Standard Bank Offshore Trust against NIB. And then I served as the lawyer for NIB. As the first defendant, Eland was the second defendant, but had a completely separate legal representation. So I've never served as their lawyer, so I'm not conflicted in any way. I also want to put it on record that I am not aware of this arbitration that you have referred to. And Mr. Chairman, I believe we are a committee of parliament, but there are certain rules and practices and conventions of the legal profession that we need to abide by very, very carefully. When a matter is pending before arbitration, you are not even supposed to discuss it. That's what is the position. Even when an award has been granted, especially when it is before bodies like the London Court of International Arbitration, the International, the Permanent Court of Arbitration, etc., you are not supposed, to discuss them. But as Attorney General, I will take all the steps that are necessary, as I said, to protect the interests of the Republic. Because once I'm sworn in, the Republic is my One is the only client that I have. And I must act in the best interest of the client in accordance with the ethics of the profession. So I will do everything in my power to ensure that we defend vigorously the interests of the Republic in this arbitration that you are referring to.
Thank you very much for your answer. I will allow you one follow-up question, if any.
Thank you very much, Mr. Chair, and thank you for your generosity this evening. Mr. Chairman, I think it will also be hugely unfair for the Parliament of Ghana to be precluded from discussing a matter because it's also pending before the arbitration, because it has significant bearing on our finances. And as we all know, we are not in normal times as far as revenue is concerned. The matter that I raised was to draw your attention. Once you are not aware that they have filed an arbitration claim of $320 million, I'm only informing you in advance so that, God willing, when you are gifted with that opportunity, it should be one of the issues before you. Because once they have made that claim, it is clear that they are taking steps to extract that from our very dry pocket as well. Thank you.
Is that matter still pending?
Yes. Because in fact, they have filed a claim in November, and that's why I'm informing the incoming Attorney General about it.
Well, be guided of the fact that we cannot be commenting on the matters of this.
I take you from the Chairman.
Thank you very much. It's done the last question. No, it was not really a question. You are just seeking the indulgence of the nominee. Is that also?
Exactly.
Then I came in to say that, is that matter pending a judicial decision? We cannot be seen to be commenting on the matter sub judice, and you take a cue from it. Is that not so? So I am most grateful for you taking a cue from it. It's now the turn of Honorable Patrick Yao Buama.
Honorable Adongo, you are here for the finance minister, so you can leave. Why are you questioning the chairman? Thank you very much, Chairman, and the opportunity. Let me use the opportunity to congratulate my lecturer and senior brother and a firm believer of the Mischief School. And I'm sure Professor Kumadu will be very happy to see you in the chair. Congratulations, Doc. Doc, we've been talking about ORA, special prosecutor, and what have you. People want to find a very quick way in administering criminal trials in this country. The immediate past Attorney General came to the floor, introduced an amendment to Act 30. It went through first reading, second reading, and a consideration stage. But it could not see the light of day because we could not take it through the clause by clause and also the third reading. Would you consider reintroducing the bill to enable your office take the necessary steps in the reforms proposed therein in our criminal justice system? Thank you very much.
Yes, Mr. Chairman, thank you. If the honorable member is seeking to know from me whether in terms of the scope and substantive content of that bill, it will be introduced as it was, my answer is no. The reason is because I disagree fundamentally with some of its logic. For instance, the whole idea that preliminary applications are being used to delay and stymie the conclusion of trials, I disagree with fundamentally. I think that lawyers should be allowed, if there are technical issues that judges have overlooked, they should bring applications, as many applications as they can. it is incumbent upon the judiciary to dispose of those in an expeditious manner so that the substantive trial can proceed. To bring statute, to basically try to constrain lawyers, from filing preliminary applications. Some of them are, fundamental in terms of seeking to do right by the law and procedure under Act 29 and Act 30. So I disagree fundamentally with it. I will take a critical look at it. I took part in the consideration, but I had fundamental issues with it. I'll take a look at it and see if it should be ever tabled at all, or that the status quo ante remains.
Thank you very much. Your submission is in tandem with the views of the Constitutional Legal Committee at the material moment. Why should we be in a hurry to convict people? I think anybody accused should be given all the opportunities to defend himself.
Yeah, Chairman, you and Honorable Ayine were very key on this bill. Let me go ahead and ask my question. I'm very satisfied with his answer. Honorable nominee, your office, your former office, and I believe, God willing, this House will approve your nomination to be AG, used the staff and the resources available at the AG's department to fight some arbitration cases. They did not hire any external or foreign counsel to assist their office, and they were successful in most of the cases. I'm sure you're aware of it. The ADR Center has been activated and set up in accordance with law, for which I believe that the forum for some of these arbitration proceedings ought to be Ghana, to save cost and to use the capacity. You are going to occupy the biggest chamber in the country. Are you going to assure the country that you will not expend so much money in the hiring of foreign counsel and you situate arbitration within the confines of the country so that lawyers and practitioners and the big staff that you have at the AG's department will have access to the ADR Center and practice their profession? Thank you.
I will otherwise term your question, the bar must prosper. Honorable nominee, you may proceed to answer the question.
Okay. Thank you very much. The use of in-house expertise is not new, but sometimes it may be the case that certain matters are specialized areas. There's no in-house expertise, to handle them. And sometimes they are also complex, and if the jurisdiction is not Ghana, and you're not familiar with the law and practice of the seat of the arbitration, you have to be careful that you take, you have to be careful in not disregarding any advice to bring in lawyers from that jurisdiction in order to be able to conduct the case very well. So yes, I will consider the use of in-house expertise, but it's not exactly true that they use in-house lawyers throughout. The Attorney General kept saying that, but during the transition, we had evidence that they consistently paid foreign lawyers millions of dollars to do cases for this republic.
Honorable Boma, you have a chance to answer.
It's a very important question. And I want to elicit the views of my respected senior on the jurisdiction of the Supreme Court. Very wide. I ask this question every year, and I want to hear from my senior. You know the jurisdiction of the Supreme Court is very wide. From appellate, you know everything. I need not go over it. Do you think the current composition of the Supreme Court ought to be augmented with some new appointments? And what do you think must be the ceiling, given the fact that some people don't even understand the workings of the courts? And do you think they have the capacity, as we sit here now, to adjudicate on all the matters pending before them, from chieftaincy to appellate to whatever? A lot of them, about 7 of the jurisdiction.
Honorable Boama, if you said some people, who are those people?
Not every person understands that the Supreme Court handles a lot of matters, apart from what they perceive to be only political or constitutional matters. Some may be appellate matters. They have jurisdiction over chieftaincy matters originating from the House of Chiefs or the judicial councils, judicial review matters, and what have you, invoking the original jurisdiction of the court under Article 130. A lot more, about 7 or so. Election petition. And you have only 11 people handling all these matters. That's why I'm asking him. That's the gravamen of my question.
Very, very well. Yes, Honorable Nominee.
Yeah. Thank you very much. Mr. Chairman, I agree with the Honorable Member that the jurisdiction of the Supreme Court is very wide, and he has already enumerated them, so I don't need to repeat them. But you can deal with the issue of the caseload in two broad ways. One is dealing with them through the adoption of very efficient mechanisms of deciding cases. All right, so I give you an example. In the United States Supreme Court, which has only 9 members, okay, and they have operated with 9 members for over hundreds of years. The United States of America is bigger than this country. Cases come from the district court all the way through the various circuits, okay, and their circuit courts, like, you know, the 9th circuit, the 6th circuit, and so on, are very big. And sometimes, if there's a federal element in a state matter, it can emanate from a state Supreme Court to the United States Supreme Court. And yet they still have only 9. You know how they deal with the cases efficiently? The judges, for every case that is coming, they look at the brief, and if they have already decided the matter, they simply let the registrar write a brief note, and it says set denied. All right? Set denied means that the justices are not interested in looking at this matter. And it's a very well-known procedure. So if you are a practitioner before the United States Supreme Court, you have to be very, very good at distinguishing cases to be able to convince them, you know, to take up, you know, your matter. So if it comes to them and they let their research, what they call them the clerks will review, they'll go to conference, and then they tell the registrar, right, set denied. That is it. You're not going to waste the time of the court by coming to appear before the court and call, for the case to be called and so on. I think that we should adopt very efficient, procedures like that, because sometimes people take very frivolous cases, frivolous appeals to the Supreme Court, for instance. I remember once I was before the court, and then somebody brought an appeal that had to do with the fact that he, the lawyer, was not there when a decision was granted against him. So he took this appeal all the way from the High Court to the Court of Appeal and then to the Supreme Court. And the Supreme Court was empaneled to hear him. It was so frivolous. So they gave it to him by way of speaking. They gave it to him that morning in front of all of us. So we should have procedural mechanisms that will sieve out all the frivolous, appeals so that the justices are not burdened. One way is also to increase the numbers. But then the court itself, through the administrative, the exercise of the administrative powers of the CJ, should divide itself into specialized divisions, all right? So you can have the Supreme Court Constitutional Division, and you have 5 justices very specialized in constitutional law who will quickly deal with these matters, okay? And so on and so forth. Of course, you have some of them who are experts in criminal law, like my former teacher, Justice Henrietta Mensah-Bonsu. She could lead a panel of justices who will be dealing with criminal appeals. You know, so specialization may make the court more efficient, and then the burden on the court will be reduced. But that would mean, for instance, that instead of 11, we may have 15, so that 5 each, could deal with, because the court is properly constituted with the Chief Justice and 4 other justices, of the court. That is what I would say for now.
Thank you,
Thank you
Dr.
very
Ayine,
much.
and congratulations. I wish you the very best.
It's now the turn of Honorable Deputy Minority Leader.
Thank you very much, Mr. Chair. I'd like to congratulate the nominee. It's a very good associate of mine. We've been to several programs together, and I've listened to him, to his lectures, and I must say that I don't even have the locus to be asking any question, but something is very dear to my heart, and which I must pursue. I remember in the previous Mills Mahama NDC administration, in which you served as a Deputy Attorney General, the state lost a number of international arbitrations and local cases at huge cost of the state. An example is the Balkan arbitration, in which about 30 $13.5 million was awarded against the state. My only question is, how are you going to avoid the occurrences of these situations? Thank you.
Honorable nominee.
Yeah, thank you very much. Do our best in the department to ensure that we negotiate well as far as the agreements are concerned. We do not take steps to abrogate when we know that the state will incur liability. We make sure that public officers, who are involved in in these transactions, do right by conduct. I think that we should begin to also punish, such people when they, misconduct themselves. That is all that I'll say for now. So when they know the legal consequences will be adverse, they will be careful not to arbitrarily terminate and then bring about judgment debt.
Thank you very much. Any further questions?
Yes, thank you very much. What would you do in your capacity as a Attorney General to continue the tradition of a zealous defense of the state's interest in international arbitrations? What specifically will you do? Yeah.
Thank you. Any answer to the question?
We definitely will be putting our best foot forward by getting lawyers, either local or international, that are knowledgeable, that are skillful, and that have integrity to represent the Republic and defend its interests, before these arbitral tribunals.
Thank you very much. Thank you. It's now the turn of the minority.
Professor Ayine, congratulations. Your academic credentials and prowess is well known, but I know you as a man of fashion. And I've always admired you for that. And I'm sure that as Attorney General, I don't know whether your fashion will change, but congratulations. But I have one important question for you. Ghana ranks 72 out of 180 countries in the 2023 Corruption Perception Index, indicating persistent challenges with the issue of corruption. What innovative and practical measures will you champion to strengthen the capacity of anti-corruption institutions in the country?
Thank you for your question. Any answer?
Thank you very much, Honorable Chairman. Just to let the nominee know that my fashion taste will not change as Attorney General. The Honorable Member, I'm so tired. I'm reversing the cut. Yes. When it comes to the issue of corruption, as a country, we've tried various mechanisms, we've tried various institutional measures. We formed commissions of inquiry. If you go back to our history, the Olenu Commission of Inquiry was into the sale of import licenses and the bribery associated therewith at the Ministry of Trade. For the lawyers around the table, you remember the case of Akenya versus the Republic. That case, arose out of the Olenu Commission of Inquiry report. So using commissions of inquiry has been one of the things that we've used to fight corruption. Of course, constitutionally, you remember that STRIGE is also another institution that has an anti-corruption mandate. And at the beginning of the Fourth Republic, you remember very, very well the work that its first chairman, Emil Schott, did with, high public officials appearing before the STRIGE. Some of it went to the Supreme Court in challenges, and there are decided cases dealing with the procedures that were adopted and so on. We've had, various other bodies that we've used and institutional measures that we've used to fight corruption. So, Mr. Chairman, there is no shortage of institutions. reported, the evidence of it is gathered, and so on. So in every district, we'll implement it and then have a hotline that can be used to report, information about corruption. So the anti-corruption institutions, okay, should not be thin on the ground or centered in Accra, and depriving ordinary people of the opportunity to report, acts of corruption. And of course, under the Whistleblowers Act, when you report and there's a recovery, you are entitled to 10%, a percentage. And I remember a whistleblower was actually paid. The Honorable Atachia, eventually, if you want to, cross-check what I'm saying, you can ask him. The Honorable Atachia represented the whistleblower in his pursuit of the 10%. We agreed to pay. When MPP took over, there was some hanky-panky, and then the whistleblower had to go to court. Whistleblowers to report. So, Mr. Chairman, we need to operationalize and make sure that the anti-corruption institutions, the anti-corruption measures permeate all the way to the local level. That, during the revolution, of course, there were excesses, but during the revolution, the Honorable Cletus Avoka is here. Those days when we were young men in Bolga, they were the revolutionary lawyers. And of course, the reports, they caught many people, civil servants, public servants, engaged in bribery and embezzlement. And they were tried by the tribunals, and in some cases by the courts. In some cases, they were sacked. I think that those radical measures need to be reintroduced. Thank you, Mr. Chairman.
Chairman, no further questions. Congratulations.
Thank you very much. It's now the turn of Honorable Minority Leader.
Council, congratulations.
Thank you, Mr. Chairman.
Chair, I want to take my respected colleague, learned colleague, to his CV, page 1. Page 1 of your CV has no biodata of you, so can you graciously provide us with your biodata?
Okay, so for the record, my name is Dominic Ayine, and I was born on the 6th of January, 1966. Mr. Ayine Atenga and Madam Ateni.
What's your address, please? Your residential address?
My residential address is number 3 Kofi Annan Avenue, North Legon, Accra.
Your postal address?
P.O. Box LG 70, Legon, Accra. I still use my address, the address that I was using when I was a lecturer. It's allowed because I'm still associated with the University of Ghana.
Now, have you paid all your taxes to date, or have you made arrangement to meet those obligations to the state?
Mr. Chairman, actually I have a credit of 470 cedis that the Republic owes me. In other words, I've overpaid. On my tax, clearance certificate, which I can present to the committee.
Do you immediately remember how much tax you paid to the state last year, for which you have gained this credit?
No, please.
If if given the opportunity, would you be able to furnish this committee with the amount of tax you pay to the state in the year 2024?
Yes, Mr. Chairman. I can furnish the committee with all my tax record, including those from my law firm. I'm very, very, very up to date with my taxes. I don't joke with it at all.
Chair, I'm very specific in my dealings with my respected colleague. I'm asking about your 2024. I'm not talking about other matters.
Yes, yes,
2024.
yes, Mr. Chairman.
Very well. Chair, may I know from the nominee whether he ever represented Fidelity Bank as its external solicitor?
Yes, Mr. Chairman, I've represented, and in fact, I'm still representing Fidelity Bank as its external solicitor in a case that I filed in the High Court for damages for defamation.
Are you on retention?
No, I'm not on retention.
Are you also a solicitor for the Electricity Company of Ghana?
No, I'm not.
Have you ever been a solicitor for the Electricity Company of Ghana?
Yes, I have been before. I've represented them, the ECG, in one matter, which was before the High Court, which case has been disposed of. And then also, I was actually hired by an English law firm called Omnia LLP. You know, that was hired by ECG as their lawyers before the London Court of International Arbitration, and I was hired as the Ghanaian law expert, and I appeared before the tribunal on behalf of ECG.
Very well. Was that case in respect of the PDS matter?
Yes, please.
Very well. Leonard, so how was the outcome, what was the outcome of the PDS trial?
Mr. Chairman, let me make it clear. I was lawyer for ECG, that is Electricity Company of Ghana, not PDS. But a dispute was brought by PDS. I want to make it clear. I mean, I know why I'm saying
Chairman, so let's help ourselves with respect. So PDS sued the Electricity Company of Ghana.
That is correct, Mr. Chairman.
Right. So ECG then became a respondent in the matter.
That is so, Mr. Chairman.
Yes. So for the records, you were one of the attorneys for ECG.
That is so, Mr. Chairman.
Very well. So having landed on that point, I shall proceed to ask you, what was the outcome of the said arbitration of which you were counsel for ECG, please?
Mr. Chairman, we are expecting the award in May. Everything that I was supposed to do as counsel has been done, except that my fees are outstanding.
You mean part of your fees? You mean part of your fees is outstanding?
Yes, part of my fees.
Yes. So because you were paid some, and your later invoices are outstanding. That is true.
That is so.
Yes.
Yes, but let me put it on record that I was on the side of the Republic. I want to put this on record, that I'm on the side of the Republic. The Republic is the sole shareholder of PDS, of ECG, and I sided with the Republic. I was invited by PDS to be their lawyers. I declined for ethical and political reasons. I want to put that on record.
Chairman, I would want to plead with the nominee that much as it is his desire to provide additional information, I would plead with him to limit himself to my question, because I do not want to prolong matters. If you bring in other matters, then you would lead me into asking. So I want to make it as short as possible. Is that okay?
That is okay, Mr. Chairman.
Now, Honorable Nominee, can you tell this committee the period within which you acted as solicitor for ECG.
You mean in respect of the
arbitration, the PDS?
The arbitration has been going on for, Mr. Chairman, the arbitration has been going on for the last, I think, 1.5 years. Yes.
Really?
Yes.
We are in 2025.
That is so.
Is it your case that
it started way before 2024?
Yes. So that's the clarification I wanted to provide. Were you hired in 2018?
Now, in 2018, maybe, Mr. Chairman, he's confusing two matters. There was another matter, that is ASG versus ECG. That is all, that's the short name of the company is ASG, All Services Group. All Services Group and, ECG, okay? So that arbitration was the first time that Omnia LLP requested my services, and then they hired me, and because I performed, to their satisfaction, in the PDS matter, they came back for me.
So when did the PDS sue ECG?
Mr. Chairman, I can't remember off the top of my head, but I can provide a committee with the accurate information.
I can give you the opportunity with the leave of chair. I know you did a case with your respected junior, whom you've trained so well. I watched him at the Supreme Court with a lot of admiration, and one must compliment him for his great advocacy. He's right behind you, since most times he was holding your brief. Can you, with Mr. Chairman's leave, take the date from him? He's behind you. If Chairman will grant leave.
No, I think the witness is under oath. We cannot allow another person to interfere. So he promised when given the opportunity, he will let you have the date. So we take the witness words.
So, thank you, Chairman. Thank you. So, Leonard, in taking up the case, Electricity Company of Ghana being their counsel, you believed in their case, didn't you?
Very well, Mr. Chairman. I would never take a case. My juniors know that I won't take a case unless I believe in the merits of the case.
And you believe that your client had done nothing untoward in its decisions leading to the termination of its contract with PDS?
Mr. Chairman, the witness really provided the answer that he will never take a case unless he believed in.
And additionally, we are still expecting the award. So I wouldn't be permitted ethically to start discussing the merits of the case.
Chairman, you and I are practitioners, and you know I will respect those barriers. I'm not going to ask you to narrate to us those details of the case. All I want to ask you is that you believed in the merit of your client's case, to the effect that, in your view, your client had not done anything wrong in the handling of its contract.
That is correct. That is correct, Mr. Chairman.
Thank you.
Hold on, nominee. Honorable member, by the indication from the nominee, the case is pending award. Is that not so? So
that is so, Mr. Chairman.
So it is a matter under determination, and by law, can we be going into the merit of that particular matter, whether you believe or you don't believe in it, since it is pending a judicial determination.
Chairman, I appreciate your intervention. I would humbly plead with you one more time to allow me to flow. I would not cross the barrier, and I believe that you've heard me loud and clear. Now, Honorable Nominee, and let me say to you that though we have political differences, I respect you for your stance in a lot of matters of national discourse. And without prejudice to any member of the majority caucus or any member of the NDC, you know that you are the only person who has a picture with me, and that picture is in my office. It's there on a purpose. You know that. So I laid that foundation to ask you this other question that is coming up. You took this case with ECG, well aware of the politics of the country at the time, weren't you?
That is so, Mr. Chairman. I operate within the political legal context of this country, and I'm always aware of the political dynamics, and I consult widely before I do what I do.
So the point I want to make is that you were aware that where you stood in the political space, you were against the tide in taking up the ECG case.
I didn't think of any tide. I thought about the interests of the state of Ghana.
I agree. And that is why I'm celebrating you for that which you did. That politically, the tide was against the government of the day. But here you were, because of your professional stature. And I was happy you made reference to a third-party legal firm that actually spotted you and pulled you out of the lot to be the representation, the attorney for ECG. So that's what the point I want to make, that politically the tide was against you. Would you agree?
I was not conscious of any tide. I wasn't swimming against any tide. I just took a professional decision to agree to serve as counsel in this matter. And the ECG is owned by the Republic, owned by the state. It's a limited liability company with its own board of directors and so on. I didn't think about the political implications of representing ECG, but I knew that the politics around PDS was not, because I also believed in the fact that there was wrongdoing on the part of PDS, and I wouldn't accept a brief, from a company that I believe was in the wrong in respect of a transaction.
So you are saying that ECG is a limited liability company with its own board. So it's a separate corporate entity from the state, though the state is a sole shareholder.
Yes, Solomon versus Solomon.
No. Yeah. I just want to ask that for emphasis.
Yes.
Therefore, the conduct of its board is completely independent from the state, correct?
That is correct.
So if, as Attorney General, you are to advise the state in a situation where the minister, the sector minister, wants to, through a public statement, dissolve the board, would you find that to be appropriate?
Yes. Yes.
Kindly explain.
Yes, Mr. Chairman, because the appointing authority has changed.
Get my statement in question, my question in context, so that you don't have what I'm saying. The question is,
Yes.
since you acknowledge through Solomon versus Solomon, they're saying that the body, the company is an independent, institution separate with its own board. I'm asking whether a sector minister will be right in issuing a statement to dissolve a properly constituted board of that entity which you acknowledge as a corporate body with all its rights engraved in law.
Well, we can haggle with the form that it has taken, but that is notionally equivalent to a resolution of the shareholder dissolving the board.
So let's go a bit into company law, since you are introducing that. So my basic understanding of corporate law is that the shareholders have such rights to take decisions on the appointment of the directors of the firm. And once those directors are appointed, they assume their independence, of course, subject to the articles of incorporation and what the shareholders will so direct. They may have their own vision. Are you saying, therefore, that by virtue of the state being the sole shareholder, without convening an AGM, the sole shareholder, as represented by a sector minister, can sit in an office and issue a public statement to dissolve the board, and that would be sufficient in law? I just want to know from you.
Mr. Chairman, that is why I said we can quibble about the form that this has taken, but a sole shareholder cannot hold a meeting with any other person but itself or himself, right? That's what it is meant by sole shareholder, right? So if I were to advise the minister you're talking about, I would have drawn up the resolution, right, and served it on the members of the board, that by this resolution dated the 13th day of January 2025, the board is hereby dissolved. And that would have been very, very appropriate. Okay, so the form that it took is probably what you are quarreling with. Maybe if it is in the form of a letter, without any reference to the shareholders' rights and so on and so forth. That is the, but I mean, that is what you are quarreling about. But as Attorney General, I'll advise that the right thing be done.
Chairman, I think one of the things for which the nominee has earned the respect of many colleagues is his position on the law. And let me say, I appreciate your very candid view on this. And I pray that you will walk the talk and ensuring sanity as we get along, because this our politics, it is party go, party come. And we need to assure those who take up responsibility in running state institutions. Now, I will proceed to my next observation about you. None of us here can be perfect. There are times that we lose it, and there are times that we get it all well. have you ever felt frustrated as a lawyer in any matter that you've handled, whether in your private practice or in being a lawyer for the states in your previous life as a deputy attorney general? Was there any point that you felt very frustrated in any brief that you handled?
Well, as professional lawyers, we get frustrated and exasperated on a daily basis. Sometimes it may be coming from the clients. Sometimes it may be coming from the courts or tribunals that we appear before, and so on. Yes, so I have been frustrated before, but that is normal. It's part of, it's part of life.
So, have you ever felt disappointed in an outcome of a case, whereupon that led you into some public outbursts?
Mr. Chairman, I don't know what the honorable member is driving at, but if you realize, okay, I don't run public commentaries on cases that are handled. As a matter of, the practice and tradition of my firm, we don't run public commentary unless the matter is political in nature and there's a need for some clarification because of the politics inherent in the matter. But as far as my commercial practice is concerned, yes, sometimes I lose cases, but I don't run commentary on them publicly.
Chairman, please, I claim your attention for the specific language I'm using for my question. My question is, have you ever been disappointed in the outcome of a case, meaning a final judgment in a case you did, whereupon you made some public statement? I'm not talking about running commentaries on a case you do. I am asking whether you recall any public outburst emanating from a judgment in a case that you did.
Mr. Chairman, I cannot recollect. So if I cannot recollect.
Honorable Dominic Ayine, in the Wyoming case, where my Lord Ajet Nassam presided, you, the media, reported you to have said, that is the submission of no case, where the judge ruled in favor of Mr. Woyomi. In other words, his application that there was no case to answer was upheld, and your opposition to that application was rejected by the court. The media reported you to have said that the judge had made up his mind even before the case. If that report by the media is correct, on hindsight, do you think that you were right?
Well, Honorable Minority Leader, the witness indicated clearly that he doesn't run commentary. He cannot remember. But you keep on asking about So the witness will want to answer. Proceed and answer.
Mr. Chairman.
Counsel, hold on a second. Chairman, I've used the word plead with you for the umpteenth time. Chairman, please, stop it. Some of our colleagues are expecting a certain level of conduct from us. I beg of you, let him proceed. Let him proceed, please. Let him proceed.
Mr. Chairman, thank you very much. I think context is very important. Context is very important. I do recall that when the ruling on the submission of no case was granted in favor of Mr. Woyumi, I was not directly handling the matter. I was actually supervising the current DPP and a team of lawyers to handle the matter. But then the judge, in his ruling, took a swipe at the Attorney General, that is my boss. He took a swipe at the Attorney General because this was a case between the Republic and Mr. Woyumi. So he took a swipe at the Attorney General. We read the ruling in chambers. We wanted to ignore it, but then lawyers were called who were then running adverse commentary against us in the matter. And so we took a decision in chambers that we needed to respond and to explain. And Mr. Chairman, there's a lot that I know about a judge that you don't know. So don't open a Pandora's box.
Chairman.
Thank you very much.
Chairman. Of course, I recall former U.S. Defense Secretary Donald Rumsfeld come out with this saying that there are known unknowns and there are unknown knowns. I'm sure that is the area you're trying to venture into. However, the unknown knowns which you want to refer to are not a matter that the public became aware of because you did not want to put the unknown knowns out there. That is why you didn't put it out there. I am only interested in the fact that the ones that you decided to put out there. And that is where I seek to ask you a question on. You've explained that it was in context, and I think that's fair enough. I wouldn't belabor. But let's also move to another point. The Supreme Court. There came a time where the Supreme Court made certain pronouncements, which I'm sure you were not too pleased with said pronouncement, and that resulted in some comments by you, and the Supreme Court was not happy, and eventually the gentleman in you, as we all know, you conceded and put matters to a peaceful rest. What have you to say to young practitioners who will be dissatisfied with Superior Court decisions, given your own experience in what happened?
Mr. Chairman, thank you very much for the question. Once I am approved and sworn in, I will be the leader of the bar. And I'll set a very good example. I think even in private practice, you would admit that I am an example. I've never been engaged in any unethical conduct in my practice. So I will lead by example, and that will be from day one. So I wouldn't encourage any young lawyer to, out of frustration, take the judiciary to the cleaners. Because remember that I am not only Attorney General, Principal Legal Advisor to the President, but I'm also the Minister of Justice. I will be the Minister of Justice, meaning that the justice sector will be under my ministry. That will be the principal, apart from the Attorney General's Department, to be the principal sector in terms of policy and in terms of law that I will be superintending. And so I would want to have, a very good relationship with the judiciary, a good and respectful relationship with the judiciary.
Chairman, we have become aware of an executive instrument dated the 9th of January 2025. And this executive instrument takes its strength from Section 11.3 of PNDC Law 327. It lists a number of ministries. Conspicuously missing is the Ministry of National Security. Now, in the Securities and Intelligence Act, there is a provision for the creation of the Ministry of National Security. Going in as the Attorney General, would you advise the President to amend this EI to reflect this new enactment that Parliament has passed? Because it appears that His Excellency solely relied on the PNDC Law 327 without paying due attention to the Securities and Intelligence Act, which Parliament passed recently.
Thank you, Mr. Chairman. And I have, previously had to have, discussions on this matter. But in terms of the hierarchy of laws, of course, the Act supersedes the executive instrument. And once the Act provides for a Ministry of National Security, and the principle of law is that Parliament does not speak in vain. We will, take a second look at it and then advise the President accordingly.
Thank you very much.
Honorable colleague.
And you. You have a long way to go, Honorable Leader.
Chairman, kindly stop this act.
I'm just asking.
Chairman, kindly stop this act.
Because you
Chairman,
seems to be taking the whole day.
Chairman, kindly stop this act.
Well, honorable members, I think there should be a ceiling on a number of questions that the leadership is also supposed to ask, so that we don't go to town. We go straight to the point. So, at our meeting, we need to take a decision as to the number of questions that leaders are entitled to ask.
Chairman, indulge me. Chairman, indulge me. Chairman. Chairman. He's not even listening. Chairman. Recognize me. Recognize me. Recognize me. Chairman.
Chairman.
Listen to you.
We should allow a free flow of proceedings. Okay?
I beg of you. Honorable nominee, in Article 181(5) of the Constitution, that provision in the Constitution received some judicial pronouncement. The very first one, I believe, the Clomega case, Clomega versus the Ghana Port and Harbors, where the Supreme Court had an opportunity to make some pronouncement. I believe that the court made some consequential orders to the effect that Parliament would have to ensure certainty in that provision of the Constitution by enacting a law to regulate 1815. It's been long overdue. We don't have a law yet. In the Sebe Yabwa case, the Supreme Court even distinguished the law further, made a clear path, and said that even in situations where the transactions involve state entities with its own board, it wouldn't be considered as part of 1815. However, they still felt that Parliament has failed in enacting a law to regulate 1815. Now you have the opportunity. Can you assure the country that
he has the opportunity or is going to have the opportunity? Or if he gets the opportunity?
Yeah.
Chairman, I think this question on Article 181,
your leader is speaking.
I sought leave from the chairman.
And what about?
I sought leave.
In relation to what I am saying, that now you have the opportunity or now you are going to have the opportunity.
Bringing a very important matter to
is
your
it on that issue?
I'm bringing a very important matter to your attention. That the Speaker set up a committee on Article 181(5). And that report and bill is ready. That's for your information.
Thank you very much. So, leader,
and Mr. Chairman,
your wedding, now you have the opportunity. Do you still stand by it?
Mr.
Or
Chairman,
now that he's going to be given the opportunity?
Yeah, just to add to what the Honorable Patrick Boma has
Honorable nominee, hold on a second. Let me handle the matter with the chairman. Chairman, let me flow, okay?
You have been flowing on and on.
Let me
but
finish
your statement is as if he has been approved.
Chairman.
He's now the Attorney General. Meanwhile,
Chairman.
we are in the vetting process.
Chairman, I'll go back to the question. Honorable nominee, now you have an opportunity back to the Attorney General's chambers. Will you assure us that steps will be taken to enact a law to regulate 1815?
Thank you, Mr. Chairman. Just to add to what the Honorable Patrick Boma has said in answer to your question, Mr. Speaker set up a committee. On the side of the then minority, I was a member with the Honorable Dr. Ato Forson, and then the Honorable Elizabeth Ofoswajari. And we came up with a bill. I'm a co-author of that bill with the Honorable Joe Gatti. And the bill was supposed to be laid in Parliament before we rose. But because of certain developments that took place, the bill has not been laid. I'm very satisfied being an author of the bill, we took, part, the Honorable Patrick Boma and I took part. We even had a stakeholder consultation, and the bill is ready. So it was Parliament's bill and was being sponsored by the members of Parliament from both sides. If Mr. Speaker still has that intent, I will allow that process to flow to its logical conclusion. Otherwise, I will adopt it as Attorney General, and with the backing of the Minister of Finance, Dr. Ato Forson, we'll bring the bill back to Parliament, and then it will start the process of first reading through to passage. So that is what I can assure the country.
Very well. So, Honorable Nominee, you have become aware of the ORA. You've become aware of the ORA.
Yes, Mr. Chairman.
In your view,
Oral was an integral part of our campaign message.
right.
And our campaign, I was a surrogate campaigner for His Excellency John Dramani Mahama, and he's committed to oral, and I'm committed to it as well.
Right. So, good. In your view, do you see this committee as a constitutionally empowered committee? You think that it has a constitutional backing or any statutory backing to have this committee in place?
Well, if by constitutional backing, there are two ways by which the Constitution would have backed oral. That is, if it was specifically stated in the Constitution, such as the Commission on Human Rights and Administrative Justice, which is not the case, or if the Constitution provided the framework, the constitutional framework for the establishment of a body called the Operation Recover All Loot. But I think I stated quite, clearly, and I don't know whether you were in the room when I gave the answer that one of the fundamental principles of the Constitution is the principle of accountability. And oral is about exacting accountability. And I think that my colleague, senior colleague, and partner, the Honorable Mahama Yarga, added substantive, sense to what I did, with the answer I gave, by making a reference to Article 41F of the Constitution, and the obligation on all citizens, to take steps, to protect public property and to avoid waste of public, funds. So I think that oral is not unconstitutional. Oral is not illegal. Just because it was not set up by an act of Parliament does not necessarily make it an illegal body. So it has constitutional backing in terms of the fundamental values of the Constitution.
Chairman.
Well, before you come in, I recognize Roxanne Dafamapo on point of information.
Chairman, thank you very much. Chairman, the minority leader in submitting just a minute or two ago in respect of the Act 1030. Act 1030 does not provide for the establishment of national security. It provides for the functions of the minister. That's what it provides. And so there are two markedly different issues.
Thank you very much for the information. Honorable
Chairman,
take note.
I would want to beg my respected colleague to get the law, open the provision that he is relying on, upon which he disagrees with me. He should open the provision, because the Act provides for certain ministries and provides for minister responsible for national security minister responsible for finance and all. If he's saying that there's no such provision, no, please. Honorable. Please.
So
Chairman,
Honorable Member, I recognize Honorable Ayariga to
Chairman,
read the act.
Chairman.
I recognize
Chairman,
Honorable Ayariga to read
Chairman,
the act.
Chairman.
Honorable Minority Leader, few minutes ago you said that he should read the act. And Honorable Ayariga quickly wants to read the provision. So why are you not
Chairman,
comfortable with the act being read? Honorable Ayariga, go ahead and read that.
Mr. Chairman, the Act severally makes reference to a minister. And then it goes to the definition section. And then it says, minister means the minister responsible for national security. So it could be any minister of the president that he has assigned responsibility for national security. It doesn't command the establishment or continuing existence of a ministry of national security. Even when the provision tries to define a ministry, assuming that a ministry is mentioned, it adds and says that ministry means ministry responsible for national security. It doesn't say Ministry of National Security, but the ministry that is responsible. So the president can assign responsibility for national security to the Interior Ministry, the Defense Ministry, or indeed the Ministry of Upper East. So that is the president's prerogative.
Thank you very much. I think this is a usual rendition in our laws that would define ministry or a minister to mean minister responsible. So if today the minister responsible for roads should be the minister responsible for transport, the designation will be made as such. So I do not think this is an issue that we should belabor. Yes. I mean, it is clear now. So, Leader, proceed.
Chairman, with the greatest respect, you are expressing an opinion. Don't say it is clear now. The interpretation column of Act 1030 provides for the definition of minister. I've been part of legislation, at least for the past 12 years. It provides minister means, it didn't say include. Minister means the minister responsible for national security. Then it goes on to say ministry means ministry responsible for national security. In all humility, and at the risk of sounding immodest, the argument that it could be any ministry by the president, to say the least. Anyway, again, if you go to Section 11, Section 11 provides Ministerial Security Coordinating Committee. And it provides, without limiting Section 10, there shall be the Ministerial Security Coordinating Committee, which consists of the A, Minister responsible for national security, Minister responsible for foreign affairs, Minister responsible for defense, Minister responsible for the interior, Minister responsible for finance, Minister responsible for communication, and Attorney General. So the law is very clear, and it is not a matter of the president assigning interior minister to be responsible for national security. It is provided for that we would have a minister of interior, a minister of defense, a minister of national security is there. Mr. Chair.
Honourable members, you see, at a point, the rendition changed to minister responsible, not minister of, because of these issues of realignment. So if today, a minister responsible for Greek is supposed to be in charge of the national security, he is the minister responsible for national security. That is the designation. That is the reason for changing the rendition. We could say simplicity the minister for national security, but we are saying minister responsible for national security. We've taken into consideration issues of realignment of this nature. That is why, because other than that, each time there is a change, you must come and amend the substantive law in consonance with the change that you have made. But once you say minister responsible, it is incumbent upon the president to dedicate that to a minister appointed by law. See, all the laws from 2020. I believe this is even a Cavendish drafting, of which I am part.
May I ask, whilst nobody intends to hold the hands of the minority leader, but we cannot also say that the space provided for the minority leader means that, I remember I sat here beside Honorable Ato Forson. Honorable, the former chair would always insist, how many questions do you have? Honorable Ato Forson will have to declare, I have this number of questions. Is it the case that the only way to satisfy the minority leader is to say that as long as he's got questions, he must continue, even if it's tomorrow, to be able to say that that is the only one? Chairman, I would suggest, at this point, Chairman, at this point, then the minority leader had enough time to make his point. So I think you should be beginning to give an indication as to how far this is going to go.
Honorable Chief Whip, I'll be magnanimous to ask him to ask 3 questions. Then we can bring proceedings to an end. So you may ask the first one.
Honorable nominee, if I heard you correct, if I heard you right, it is your case that the establishment of the ORA committee is legal.
Yes, Mr. Chairman, it is.
Now, you are aware.
Second question.
You are honorable chair. If you have been very calm managing, if there is an attempt to disrespect me and to create a problem, Chairman, stop.
Far from that.
Chairman,
you are putting words into my mouth. I am not in any case
I have been
disrespecting
very quiet
you,
and very
but
calm.
I think
Chairman,
you are trying
stop.
to be very abusive.
Chairman, stop it.
I'm not disrespecting you in any
Chairman,
manner whatsoever.
stop it.
Chairman, please,
I
a
am
point
not
of
in
order.
any manner disrespecting you. We've accorded you all the opportunities in this world. We have accommodated you.
Chairman, excuse me.
So
Chairman,
how do you
can
say I'm disrespecting you?
Can I respectfully go to our standing orders? Order 2 and 7.
Honorable boy, you have the floor.
Chairman, been very patient. Chairman, we in Parliament are guided by our standing orders. Order 2171 on the Appointment Committee. The Appointment Committee comprises the First Deputy Speaker as chairperson, the Minority Leader as ranking, and the Deputy Majority Leader as vice chairman, the Deputy Minority Leader as deputy ranking member, and then he lists the following. There's only one chairman. Only one chairman. We don't have co-chair of this committee. And the rules of this house is that we allow the chairman to lead us and direct everybody so that we can have an orderly business. My respected Honorable Afenyo Marcus has chaired committees, and we've always deferred to him that allow all of us to basically do the work. It is as if he is not respecting the chair. And it is completely not right, especially on an appointment committee where the whole public is looking at us. I think that where we are, the right honorable, my colleague, please, let's respect the chair. He will give you all the opportunity. But when the chair makes a determination, you will be the first to support him.
Honourable Member, your second question.
Chairman, with respect, I beg you. We've come very far with the nominee, and I think we don't want to end this day having vetted the finance minister designate, the energy minister designate, and our respected colleague in this kind of situation. I beg of you, Chairman, we've come very far. Please, let's give him the space to finish. He has guests from his constituency, chiefs. We don't want him to leave this room disappointed. We've come very far with him. Let's indulge the minority leader to end his question, please. I beg you. I know why I'm saying that. I beg you. I beg you. Let's give Kwame.
So we need to be guided. Minority leader, how many more questions do you have? I need some answer from him so that we can be guided regarding the number of questions that he has to ask. No, we cannot finish tomorrow. Well, he can say that we'll finish tomorrow. The whole world is watching us.
Yes, Honorable Chair, please. I think we've been on this committee, and we've had a case where Honorable Haruna Idrisu have been vetting and questioning until he's satisfied with it. Yes, even sometimes he starts with a warm-up and he goes, but please, I think where we are at the moment, let's try and indulge him and then finish up with him. I'm sure he's almost at the end of it.
So we just need an indication from him. How many more questions does he have? Or how many more minutes does he want to be given so that he can finish up his question? Leader, how many more minutes do you want? Or how many more questions?
I think if you leave him, he will be able to wrap up. He's here. We are all here waiting.
So, Leader, you have the opportunity to wrap up using the words of the Deputy Leader.
No, I said, you just leave him. Allow him
to wrap up.
Through the questions that he wants.
No, the word I've heard is that he should wrap up. So
Here
you have the opportunity to wrap up.
On the other side, nobody asked any questions. And he needs to also satisfy himself and make sure that the questions that were not asked are being asked at this point in time. That's how I feel it. Once you didn't ask questions, you can ask questions to that of them.
Chairman, thank you very much. Honorable nominee, you are aware as a legislator that when the former president, His Excellency Nana Addo Dankwa Akufo-Addo, in his fight against corruption, decided to set up an independent body, he had to come to Parliament to enact that law for the purposes of the office of the Special Prosecutor. You are aware of that?
Yes, I am, and I was, a key actor during the enactment of the OSP because of where I came from.
You were also a key advocate for the law to be enacted to enable the Office of Special Prosecutor have the legal powers to proceed with its work, correct?
I don't know what you mean by a key advocate. I took part in the lawmaking process. Go back to the Hansard. My initial position was that it was an unconstitutional body because it was, to me, violative of Article 88 of the Constitution, because we're taking the constitutional powers of the Attorney General and giving it to another person and seeking to say that the Attorney General that person should be autonomous or independent of the Attorney General. And I said, no, those prosecutorial powers inherently belong to the Attorney General, and no one can take them away and then say that the person should be, ring-fenced in such a way that that person, should not be controlled by the Attorney General. I made very forceful arguments to that effect, and that is how come that there were provisions, the independence provisions were watered down at my behest. And of course, I was just a lone ranger at the time, but I'm no longer a lone ranger. I'll take a look at the law again.
So now, in view of that reasoning, what you hold so firm, and if I may have to repeat, you're saying that the establishment of the Office of the Special Prosecutor took away the prosecutorial powers of the Attorney General. Now we have ORA. With investigative
power to the Attorney General to conduct criminal cases, and any other body that is conducting a criminal case is doing so on the authority of the Attorney General. Therefore, I recall that in the passage of the Special Prosecution Act, argument was canvassed to the effect that we cannot give the Special Prosecutor, by an act of Parliament, power to do prosecution. And this was heated to the extent that the Attorney General at that time agreed with our position. They used their numbers 169 against 106 to push the law, and when it gets to the third reading, the Attorney General then declined to come and move the motion for the third reading, leading to the passage of the law. But today, it's being stated that there was argument from the nominee to the effect that special prosecutors will have power to prosecute. The Constitution is very clear on power to prosecute, but not power to investigate.
Honorable nominee, my question to you is this. Here is the backing, of which you and insist that it is legal. I'm asking you, this committee is out there saying it is investigating supposed looting. Now, we have state institutions with the of corruption, conflict of interest, and certain actions of public officials. Shraj is a typical example. We've had situations where members of the public have gone to Shraj on certain matters. We have the police. The police has various units that does investigations. We have IOCO. We established IOCO, Act 804. If you look at their mandate, they have all the powers. Are you saying that this committee does not conflict the work of these statutorily established state agencies?
Mr. Chairman, no.
Your answer.
No,
No,
it doesn't. And I'm not aware that oral has been, conferred with investigative powers. They are gathering information for purposes of determining, whether or not some wrongdoing has taken place by a higher body. I remember them saying that once the Attorney General takes office, they will hand over the information. It's like a whistleblower, coming to the Attorney General with information. There's nothing legally wrong with that. So I still stand by that.
Thank you very much. I don't know why oral is posing so much threat to some Ghanaians.
Honorable nominee, if I understood you correctly, is it your suggestion that upon taking office, ORA shall cease to be in operations? I just want clarity.
Honorable Leader, the nominee never said so. So I do not know the clarity that you are seeking from something that the nominee has never said.
Okay, no problem. Honorable nominee, since Chair says you never said so, let me now ask you.
And I did not say so.
That's okay, no problem. That's all right. Honorable nominee, are you saying that because you believe that ORA has a legal backing, your office is going to continuously depend on ORA for the purposes of providing you with information for your prosecution?
Honorable Minority Leader, the nominee never said so. So you may ask another question.
Chairman, please, for the third time. Honorable nominee, as Attorney General and Minister of Justice, you will primarily rely on state agencies such as police, IOCO, and FIC for the purposes of building your case for prosecution, correct?
Well, the qualification primarily doesn't sit down well with me. Some of the institutions we've mentioned have statutory power to conduct investigation. IOCO, economic and organized crime. Period. They can investigate anything.
Thank you once again. Listening in silence.
Chairman.
Do you have any more questions?
Honorable nominee, thank you for the response to my earlier question. Now, you have indicated that the mandate of ORA is to gather information for the Attorney General. So, I want to ask you, as Attorney General and Minister of Justice, will you continue to depend on ORA within the period of your service to the state as Attorney General? I want to know from you.
Mr. Chairman, I think I have made it abundantly clear that I will depend on any reliable source of information relating to wrongdoing that will mandate that we investigate. And by the way, one of the new things, Mr. Chairman, one of the new things that I will be bringing to that department is setting up an in-house investigative unit.
Thank you very much. I recognize a supplementary question from the Chief Whip, Honorable Kwame Governor Sagboja.
Honorable Dr. Ayine, will you say, or will you agree with me, that oral is in line with Article 41F, which says, the preamble says, the exercise and enjoyment of rights and freedoms is inseparable from the performance of duties and obligations, and accordingly, it shall be the duty of every citizen, in fact, not even oral alone. F, to protect and preserve public property and expose and combat misuse and waste of public funds and property. In this case, I cite an example of what ORA put out, that an individual of this country was trying to take over land that doesn't belong to him. The individual came out through his lawyer to say it is not true. Yet ORA put out details from lands registry showing that that individual was almost illegally or taking over land that doesn't belong to him or at a price that is not fit to be sold at that price. In your case, do you think ORA has done this country good for that exercise, which is not illegal? Nobody was beaten, nothing was done to anybody, just that that piece of land has been saved for this country. Will you say that ORA has done well as far as you are concerned?
Nominee, please answer the question.
Mr. Chairman, the honorable member has described aptly how citizens comply with Article 41F of the Constitution. Thank you.
Honorable Minority Leader.
Thank you, Chairman. Good intervention by my respected colleague, Kwame Agboja. A good constitutional exercise we are doing now. So, on the Article 41 that he has introduced, the 41F, Chairman, I would want to know from the nominee that upon reading of Article 41F, which was relied on by my respected colleague, would you say that the exercise of said duties is not done in accordance with law? Because it creates the impression that it means that any citizen can get up in the name of protecting public property, go to an institution and start warning public servants, locking up offices, as we are experiencing. People are being chased out of their homes, people are being beaten, and he is on public television quoting the law and saying that Article 41F, and I'm reading it, he said to protect and preserve public property and expose and combat misuse and waste. Now, we are hearing and seeing on our TVs what is happening at public institutions, where civil servants are being locked up, people are being chased to the 41F, or set duties provided for in this particular provision is supposed to be exercised within the confines of the law.
Honorable nominee, before you come in to answer the question, you can profile your understanding of Article 41F of the Constitution of the Republic of Ghana. But there is no evidence before us that oral has gone to lock people's offices, they've locked people's houses, or they've beaten people up. So I would even urge the Hansard Department to expunge that aspect of the question so that you can go ahead and tell us your understanding about Article 41F of the Constitution of the Republic of Ghana.
Chairman, with respect, nominee, Chairman, with respect, this particular question, I did not refer to ORA. Please, I did not refer to ORA. I did not anchor it on ORA. If I can repeat it, I did not.
Well, if your reference is not to oral, then we do not have evidence before us that such a thing has happened. And that is the more reason why that should be expunged from our record so that the nominee will go ahead and then give us his knowledge about Article 41F of the 1992 Constitution of the Republic of Ghana, with due respect to my learned friend.
Okay, so then let me, just because for the purpose of clarity, let me now rephrase the question so that the nominee will not be in any form of confusion.
So that question is expunged.
That's okay.
You may go ahead and answer
that's okay. That's okay. Honorable nominee, have you become aware of post-election violence post-election violence by some